Hello class, this video is for week 8, chapter 10, and sorry about not having a video up last week. I was actually in a car accident, totaled everything out, so it was a busy week dealing with a lot of legal issues as far as the adjusters go and the insurance, but we're back. Also, one other note, the discussion board grading should be updated the next 24 to 48 hours or so. So let's talk about Chapter 10 for a little bit, a couple of things I wanted to touch on. So Chapter 10 goes into defenses. But I want to start with this premise. Before you get to defenses like justification and things of that nature, you have defenses based on the elements. And that's true not only in civil law like torts, but also in criminal law. So if you're talking about a charge of, let's say, burglary, you would look at the elements of burglary and determine if there are any defenses based on those individual elements. Then, and only then, would you move to a defense under law, something like justification or necessity or consent. So keep that in mind when you look at the elements of a crime and you think about defenses. On that subject, Chapter 10 goes into a lot of the common, or the most common defenses. One of the big focuses of the chapter is the Castle Doctrine and the Stand Your Ground laws. The Castle Doctrine goes back all the way to England. It was an important thing that a person's home was their castle and could be protected with deadly force if need be. That is unique from force that is being used outside the home. Before we ever get to Stand Your Ground laws, keep in mind that self-defense outside of the home always had an escalation element to it. What does that mean? If somebody's coming at you and they're trying to punch you, you can't pull out a baseball bat to defend yourself. You could, though, hit them back or use reasonable force to deter that harm that's going to be caused to you. The escalation was key. The other part that was consistent with self-defense was if you could, you had to retreat. And that retreat is what the Stand Your Ground law takes away. You no longer have to retreat because, frankly, many people thought that it would put the potential victim in harm's way. Imagine if you tried to flee and the person, let's say they had a gun, shot you in the back. You lose sight of your attacker. Different things can happen. So, Stand Your Ground is not new, although it's been highly publicized recently. It is a controversial topic. For those of you, whether you think you support it or don't, I would encourage you to go out to the internet and do some research on exactly how it's applied and how it's used. And I think you'll find that most of the studies on it in its application show that it's applied very fairly and very uniformly, regardless of race, ethnicity, political affiliation. So it's an interesting topic to look at. So those are the defenses as far as we're talking about force and the use of force. Beyond that, the book then gets into defenses of property. Keep in mind you can never use deadly force to protect property. There are a series of cases, a lot of rural areas, using something called a spring-loaded shotgun. Somebody would have a piece of property in a remote area, and they would rig up a shotgun. And if you open the door, the shotgun would be triggered and the person would be shot. Those are unlawful. You can never use deadly force to protect property, save for the Castle Doctrine. Castle Doctrine, though, only allows for that deadly force if you're in the home. You can't rig up your home, for instance, with a gun that goes off when somebody opens the door unlawfully or breaks into the house. So property and deadly force can never be used. Necessity, duress, the defenses of that nature aren't used a lot. Necessity defenses are oftentimes used with property cases like trespass. But other than that, it's not something that you'll see very often. On the entrapment front, I just want to touch on a couple other things. On the entrapment front, keep in mind with entrapment, you should look at the elements of it, but it is a very specialized defense, and it is a double-edged sword. Because if you argue entrapment, you are putting your client's reputation and their past on trial. You are essentially saying that that person would not have committed this crime but for the police, and therefore items in your client's past that may not have been relevant or admissible now would become relevant and admissible. So it's something that you certainly have to think of carefully before ever raising. Finally, look at the insanity portion of the book, the McNaughton rule. The only thing I really want to reference here about the insanity issue is legal insanity is not the same thing as clinical insanity, or medical insanity, if you want to put it like that. They sometimes overlap, but they are oftentimes mutually exclusive. Same thing with competency to stand trial. Somebody can be legally incompetent even though medically they may not be. Although more often than not, if somebody is medically incompetent or medically insane, they qualify as legally insane. But it doesn't always have to be that way. All right, I hope that was helpful, and please let me know if you have any questions. Thank you.